I will start my lecture. The Byzantines called themselves Romans, I Romei, their empire Basilia Romaeon, Imperium Romanorum, and their princes emperors of the Romans, Vasilevston Romaeon, until the fall of the empire in 1453. Because Byzantium inherited its main political, cultural, and social institutions from Rome. Similarly, Roman law constituted the basis for the Byzantine legal system. For many centuries, the great Justinian's codification was the cornerstone of Byzantine legislation. Of course, over the years, these Roman codes were adjusted to the current circumstances and then replaced by new codifications written in Greek. However, the influence of Roman law persisted, and it is obvious in post-Justinian's laws. The most important Byzantine laws, secular and ecclesiastical, are A. Secular laws. Farmer laws, Greek nomos georgikos, legal code promulgated either at the end of the 7th or at the beginning of 8th century, probably during the reign of Emperor Justinian II, which focused largely on matters concerning the peasantry and the villages in which they lived. Somewhere about that time, two other laws were promulgated. A. Soldier laws, Greek nomos stratiotikos, a collection of approximately 55 regulations, mainly penal and disciplinary for soldiers, and B. Rhodian Sea law, nomos Rhodion navtikos, a three-part collection of regulation involving maritime law. Much more important was ekloga, from Greek eklogeton nomon, literally selection of the laws, compilation of Byzantine law in 18 chapters, issued in 726 or more probably 741 by Emperor Leon III Isaurian in his name and that of his son Constantine V. Leo issued the law code in Greek instead of the traditional Latin, so that it could be understood by more people and utilized by judges as a practical legal manual. Though the Ekloga continued to be based on Roman law, editors took the provisions from Justinian's institutions, digest, codex, and novels. Leo revised it with the correction towards greater humanity. In Greek, epidiortosis isto philanthropoteron, and on the basis of Christian principles. Although a work of an iconoclast emperor, the Ekloga had a strong influence on later Byzantine legislation as well as on the development of law in the Slavic countries beyond the Byzantine Empire. The first two emperors of the Macedonian dynasty, Basil I, 867 till 886, and his son Leo VI, 886 till 1912, chose to present legal reform called the recleansing of ancient laws. During their reign, great codification of law was issued, and this flurry of legislative activity was the most extensive of any emperor after Justinian. The most important codes were 1. Epanagoge, Greek epanagoge, return to the point, more correctly isagoge, Greek isagogi, to nomu, introduction to the law. The law book promulgated in 886. Begun under Basil I, it was only completed under his son and successor Leo VI the Wise. As its name suggests, it was meant to be an introduction to the legislation of the Basilica, published later during Leo's reign. Second, Prohieron, Greek Prohieros Nomos, handbook or the law book at hand. According to the traditional dating schema, the first text published as part of the Macedonian codification efforts was the Prohieron, that used to be dated to 870 or 879, but must be regarded as the revision of the Epanagoge ordered by Leo VI in 1907. Divided into 40 titles, Prochiron was codification of certain fundamental statutes of Byzantine civil, criminal, and partly judicial and church law. As its main source, Prochiron uses Justinian institutions, but not original Latin text, then Greek translation and comments. Third Basilica, Greek Ta Vasilika, imperial laws, was a collection of laws completed circa 892 in Constantinople by order of the Emperor Leo VI. This was the continuation of the efforts of his father Basil I to simplify and adapt, chiefly the change in language from Latin to Greek, the Emperor Justinian Corpus Juris Civilis. The 60 books of the Basilica have had a profound impact on the scholarship of the Byzantine Empire because they preserve many legal documents. Fourth, novels of Leo VI, Greek Neara, Latin novella, literally a new laws, the term for an imperial edict promulgated in a collection, 130 novels, most probably on Christmas Day, 888, addressed for the most part to Leo's trusted advisor and father-in-law Stylianos Zauces. Novels of Leo VI are in fact a heterogeneous collection of his legislation that was composed in different points of his reign. The last important monument of Byzantine law was Prochiros Nomos or Hexabiblos, handbook or sixth book, a private codification of Byzantine law compiled by Constantine Harmenopoulos in 1345, a Byzantine jurist from Greece who held the post of universal judge of Thessalonica. It was divided into 6 books, each of which dealt with a given topic: legal procedure, real law, liability, inheritance, laws relating marriage, and criminal law. Among ecclesiastical law, there are 3 types of collections exposing material of Byzantine canon law. The most important are: 1. Synopsis Canonum was a brief summary of the major points of a subject. It est abridged canons arranged in alphabetical or chronological order. The first synopsis was composed at the beginning of the 6th century by Stephen, Bishop of Ephesus. As synopsis was not always clear and understandable, Alexios Aristinos, a canonist of the 12th century, wrote interpretations and additions to the canonical collection of Stephen of Ephesus. The later revision of synopsis is attributed to a scholar of the 10th century, Simon, who held the high official post of magister and logothetes. So-called systematic collections are the second type of collections, and we have so-called synagoge and syntagma canonon. The corpus canonum was not systematic and arranged according to topics. In all of its versions, the canons were arranged according to councils, and these in turn had a chronological order. The first attempt at preparing a systematic collection, id est one organized according to the topics with corresponding canons, was made in the 6th century. The need for a collection of this form was dictated by the increase in the number of canons, which made the general monitoring of this material as a whole extremely difficult. The product of this attempt, so-called the collection of 60 titles, has not survived. The only mention of its existence is contained in a prologue of a similar later work that was based on the first collection. The later work is the compilation, or Greek synagogue, of ecclesiastical canons divided into 50 titles, a systematic collection of canons organized according to content. The author was John Scholasticus, attorney at law and presbyter of Antioch and later patriarch of Constantinople. Probably circa 580, a new systematic collection was formed called the Syntagma of Canons of 14 titles. According to the unconfirmed hypothesis, this collection was created by the patriarchs of Constantinople, Evtychios, Fortunate, and John IV, Nevstetis, Faster, at the end of the 6th century. Third collection are nomocanons, compilation of secular laws, nomoi in Greek, singular is nomos, and ecclesiastical regulation, canones or canons. The most important Byzantine nomocanons are the nomocanon of 50 titles and nomocanon of 14 titles. The most important of the collection from the late Byzantine period are the Syntagma Katastichion, or alphabetical syntagma, nomocanonic miscellany, put together in 24 titles in 14th century. Each title has a sign of one of Greek alphabet letter of Matthias Blastares, a monk from Thessalonica, and the epitome of canons of Judge Constantine Armenopoulos. Next part of my paper has a title, Reception of Byzantine Law in Slavonic countries. First, Slavonic Enkloga and the so-called Zakon Sudni Ljude. In the Slavonic world, law of Byzantine origin, mostly from the Ekloga, had already been introduced by the legislative work of the mission of Cyril and Methodius, and by the Zakon Sudni Ljudi. Slavonic translation of the Ekloga was preserved in a Russian manuscript from 14th century. The translation was not particularly good, so that it was impossible to understand the number of its provisions. However, the place of origin and the date of this translation are still unknown. The oldest preserved Slavonic legal text is the Zakon Sudni Ljudem, law for judging the people, or court law for the people. Its source was the Ekloga, and it was written in Old Church Slavonic in the late 9th or early 10th century. The oldest short version contains 33 articles, primarily of penal law, adopted from the Ekloga. In later Russian annals and in the legal collection of the end of the 13th or the beginning of the 14th century called Merilo Pravednoe, just measure, there is a widespread edition of the Zakon Sudni Ljudem, consisting of 77 or 83 articles. It depends on the way of numeration, under the name Sudebnik Cara Konstantina, Code of Laws of Tsar Constantine, that is the Great. The text is of Russian origin. The place of origin of the Zakon Sudni Ljudim is topic of controversy. Scholars mention Great Moravian Principality, Bulgaria, Lower Pannonian or Balaton Principality, and the region of Strymon in actual North Macedonia and Bulgaria. Second, Slavonic nomocanons or Kornčaja knjiga. The first Slavonic nomocanon was written by Methodius, circa 868, upon the initiative of Moravian Prince Rastislav in the era of the conversions of Slavs to Christianity. Methodius translated from Greek into Old Church Slavonic, synagogue into 15 titles of John Scholasticus, and he added to it some provisions of secular law, mostly taken from the Ecloga. The so-called Nomocanon of Methodius was preserved in the Russian manuscripts from 13th till 17th centuries. Slavonic Nomocanons in Russian processing was called Kormchaya Knjiga, literally the pilot's book, from Church Slavonic Krmchia, and Greek Kybernitis, helmsman, pilot of ship, or Pidalion, from Greek Pidalion, stern or helm, handle of helm, rudder, which constituted guidebook for the management of the church and for the church court of Orthodox Slavic countries, and are transmission of several old texts. The first Byzantine legal collection that penetrated in Serbia around 1219 was the Nomocanon or Zakono Pravilo, Old Serbian Zakonu Pravilo from Zakon, law, statute, and Pravilo, canon, rule, of Saint Sava, later called Krmchia. On his way back from Nicaea, where the Serbian church got his autocephalos, Sava stopped in Thessalonica, where he probably composed the famous Nomocanon. The ecclesiastical rules of the Nomocanon were taken from two Byzantine canonical collections, with canonist glosses, the synopsis of Stephen from Ephesus with the interpretation of Alexios Aristenos, and the syntagma of 14 titles with the interpretations of John Zonaras. Among the Roman Byzantine laws, St. Sava Nomocanon contains the whole Prohiron, in Serbian translation called Zakon Gradski, and the translation of Collectio Octoginta Septem Capitulorum, selected provisions from Justinian novels. The Nomocanon of St. Sava has no prototype in any Byzantine or Slavonic codex, and it retained its place within the Serbian legal system, being neither challenged or abrogated. Already in 1226, one of its copies was sent to Bulgaria, where it was accepted as the official collection. From Bulgaria, St. Sava's Nomocanon arrived in Russia. It was proposed by Russian Metropolitan of Kiev, Kirill II, as guideline for the management of the Russian Church in 1274 at the Church Council in Vladimir. In the late 15th and early 16th centuries, Kormchaya books were revised due to the large number of variant readings. In 1650, so-called Joseph's Kormchaya, which was based on Zakono Pravilo of St. Sava, was prepared for a printing. After some amendments in 1653, so-called Nikon Kormchaya of Patriarch Nikon became the first printed version of any Slavonic Nomocanon. It was sent in all Orthodox Slavonic countries, where it became an official source of canon law and displaced all other Kormchaya manuscripts. Third, codification of Stefan Dushan. The reception of Byzantine law in any Slavonic country culminated with the greatest work of Serbian legal tradition, codification of the Emperor, Tsar, Stefan Dushan, from 1331 till 1355. This was realized in 1346, when King Dushan proclaimed himself the true believing Tsar and autocrat of the Serbs and the Greeks. Educated as a young man in Constantinople, Dushan knew very well that if his state pretended to become an empire, it should have, inter alia, its own independent legislation. Accordingly, he began preparation for his own law code immediately after the establishment of the empire. These laws are without a doubt of the type which Byzantine emperors had, namely general legislation for the whole of the state territory. In the social and political circumstances, the Serbian Tsar had to accept existing Byzantine law, though modified in accordance with Serbian custom. The completely independent codification of Serbian law without any Byzantine law could not be produced, and therefore the Serbian lawyers created special Codex Tripartitus, codifying both Serbian and Byzantine law. In the old manuscripts, Dushan code is always accompanied by two compilations of Byzantine law. The abbreviated syntagma of Matthias Blastares and so-called Justinian's law, a short compilation of 33 articles regulating agrarian regulation. Dushan's law code, in the narrow sense, the third and the most important part of the codification, was issued at councils held in Skopje on 21st May 1349, first 135 articles, and in Ceres, 5 years later, articles from 136 till 201. Although Dushan law code represents an original work of Serbian legislation, many of its provisions were undertaken from the Byzantine law, especially from the Basilica, around 60 articles. Reception of Byzantine law was present in the Danubian principalities as well. The Byzantine influence in the institution and the law of the Danubian principalities, Wallachia and Moldavia, was very strong, and it was transmitted initially along with other elements of Byzantine culture through free channels of communication, through the Serbs and the Bulgars and their processed Slavic legal works, through Byzantine officials and economic factor, and through the church. Among the most important public law ideas of Byzantine law, I shall expose, because of lack of time, only one. This is the idea of Rome and hierarchical world order. On other ideas, you will read in my paper. During the Middle Ages, the idea of Rome as the center of an universal and ecumenical empire, and the whole Christian church as well, was present with all European nations. Naturally, the Eastern Roman Empire, Byzantium, considered itself as the only successor of the Roman Empire. And according to that ideology, only their monarch could carry the title Emperor of the Romans, and a new imperial capital on East was called the New Rome. However, the idea of Rome was an universal and central, as an universal and eternal empire, became attractive to the German and Slavonic rulers. Charlemagne on the west, 800, Simon on Bulgaria in the east, 913, and Stefan Dushan in Serbia, 1346, started to call themselves the emperors. The Byzantines protested, trying to find the political and legal arguments that would contest the existence of other empires, but finally they had to accept the reality. Byzantine constitutional ideology was expressed as an hierarchical world order. According to this model, not all states were equal. Rather, a strict order existed among them, reflecting the importance of each. At the head of this hierarchy was Byzantium, the legitimate holder of the idea of universal empire, and only its monarch could bear the title of emperor. All other medieval states had a higher or lower rank, depending upon their political importance, which might vary. The heads of these states, pursuing this construct, formed so-called family of monarchs, associated in a fictive parentage. At the head of the family, as a pater familias, stood the emperor of Byzantium, whilst different degrees of relationship were conferred on other monarchs, depending upon their political importance. Charlemagne, for example, became emperor's brother, Adelphos, and his German, French, and Italian successor were proud of his adelphos distinction. English kings were merely the emperor friends, filoi, whilst at the bottom of the scale came those insignificant monarchs considered by Byzantium to be part of the household property rather than a part of a family. Within decades after the capture of Constantinople by Mehmed II of the Ottoman Empire, on 29 May 1453, some Eastern Orthodox people were nominating Moscow as the third Rome. In 1472, Ivan III, the Grand Prince of Moscow, married Zoe Paleologina, who later changed her name to Sophia, niece of the last Byzantine Emperor Constantine XI, and styled himself Tsar, or Emperor. In 1547, Ivan IV the Terrible cemented the title as Tsar of all Rus. In 1589, the Metropolitanate of Moscow was granted autocephaly by the Patriarch of Constantinople and thus became the Patriarchate of Moscow, thanks to the efforts of Boris Godunov. This sequence of events supported the narrative encouraged by successive rulers that Moscow was the rightful successor of Byzantium as the third Rome. In 1492, Zosimus the Birded, Metropolitan of Moscow, in a foreword to his Paschalion, referred to Ivan III as the new Tsar Constantine of the new city of Constantine, Moscow. In a panegyric to Grand Prince Vasily III, composed between 1514 and 1521, Russian monk Filotei from Yelizarov Monastery near Pskov proclaimed, "Two Romes have fallen, the third stands, and there will be no fourth. No one shall replace your Christian Tsardom." Thank you very much for your attention.